Welcome, everybody. This is Tim Blankenship with Divorce 661. In tonight's episode, we are talking about everything regards to spousal support. We're talking about long-term marriages, short-term marriages, all of it. How does that translate to spouse support? How long will you have to pay spouse support? We had a lot of good questions come in during the week that I wanted to go over. So this episode will be about spousal support. So we are doing this weekdays at 5 p.m. Every night we will have a different topic, and we will publish these the day before. So if you want to tune in or get an alert that we're going live, if it's something that interests you, we're also answering questions about your divorce paperwork. So if you're doing your own divorce, if you're a paralegal trying to help clients, you're a legal document preparer like we are, and you need help, that's what we're here to do. Mostly to help folks, though, doing their own divorce, doing this as a public service, if you will, just getting on for a half hour, an hour every evening and helping out folks going through the divorce process, because at least in most counties, the self-help centers are hard to get a hold of. There's long lines. They give you the wrong answers. And while we are a full-service divorce firm and would be happy to take on your amicable divorce and finalize your case, that's what we specialize in. We are here just giving some free help. So I see a couple people are joining us. If you have any questions about the paperwork or you have a judgment you need fixed, we're giving some free advice today. So feel free to ask in the chat, and I'll try to make sure to double check the chat comments. Oh, hey, Dora, how are you? Thanks for tuning in. If you have questions, let me know, please. We're trying to get this to become a popular option for folks going through divorce who are looking to get help, but can't get it through the self-help center, or maybe they don't have the money to hire someone like us to do this. So today we're talking about spouse support. It's come up a lot. I have a lot of questions to go over today. I want to just bring some of these up. And just as a side note, not an attorney, we are legal document assistants, can't give you legal advice. So what I'll be referencing is the court website and some attorney websites. That's how we get away with explaining some of the rules to you. And I see someone's named Way says need help. Go ahead and enter into the chat. If you have any questions about the process, anything other than legal advice, we'll try and work through your particular situation the best we can. You can ask in the chat, and I won't show your name or anything. Just give me as much information as possible as far as what you need help with. So what we will be doing in the meantime is, again, today's topic is spousal support, and just going to start with the basics. One of the questions that comes up is, what is the difference between a long-term marriage and short-term marriage? And I'm going to give you this information right off of the court website. Okay. Again, we're not giving legal advice. We're just explaining the rules. The purpose of this, and we do this even for our own clients, is our clients need to decide what they want to do for support, how much, how long. And so we need to explain this to them. I'll usually send these references out to them so they can see how it works. It's all about making informed decisions in your divorce, especially for our amicable clients. Just checking the comments here. Okay, so we are, I just want to give kind of the basic foundation of what the courts say. And you can find this at the courts.ca.gov if you need a reference for this. So I'm just going to read off this. Many marriages and domestic partnerships are either end without either spouse paying this type of support. So it's very true. We have clients all the time that go through divorce, and even if there would be support, meaning we run a calculation and there is some amount of support that's calculated, they don't want it. Maybe they both are working, maybe they're both self-supporting. The calculation suggests that there would be alimony, as if they went to court, the judge could order it, but they decide they don't want it, and that's totally fine. So that's the first good thing to know. Long-term support is more common when, and again, I'm references the court's website, the marriage was long, one person earns significantly more than the other. That's the biggest issue there, is when one party makes more than the other. That's, if there's one party is not self-supporting, that's where support kicks in. I have some, I'll give some examples to you on how that works and some of our existing clients and where this has come into play. So it says the judge can make three types of spouse support orders: order an amount of support that one spouse pays the other; reserve spouse support. This means that the court is not ordering support now, but could in the future; and terminate the court's ability to award spouse support to either party. So when we are talking to our clients prior to filing for divorce, what we'll talk about is if there is even going to be a request for support. And that you'll notice that that'll be on the petition. You can ask for petition to be reserved, or you say, yes, I want it as petitioner, or respondent if you're filing the response, or just reserved for future determination. The default for long-term marriages, and that's, we're going to get into what that is, but anything over 10 years, the default for the courts is that jurisdiction will be reserved for future determination. So that is an option, but many of our clients with long marriages, 10, 20, 30 years, both are self-supporting. They still want to terminate the court's jurisdiction, which you can by mutual waiver that we've talked about in the past. So now we're talking about how much and how long will it last. It's funny, I was doing a Google search just to see what the biggest topic is in related to spousal support, and everyone is concerned of how long will I have to pay spousal support if married longer than 10 years. That seems to be the biggest trigger we're talking about. And I go ahead and keep adding your comments, folks. I see them coming in. Let me just reference, see if this is something we can help you guys with. Give me 1 second. So I'm trying to be careful and not talking about too much information here. So you're asking, when can you ask for support? It says you're about to file disclosures. So if you have a filed petition, and depending on what county you are in, you can immediately request spouse support through what's called a request for order. That is a document you would file to get a court date where you'd request spouse support. You'd get that court date, serve your, excuse me, serve your spouse. Your spouse would attend the hearing. You have to do your financials. So it's probably good if you do your financial or your disclosures first. You're going to have to do those anyways. Get those in, file your request for order, and get that hearing. And your spouse will have to respond to that request for order, do their financials, and then the court will make an order for spouse support if it is warranted. Keep in mind, anything related to a request for order is going to be a temporary order, meaning you still have to finalize your divorce and all the other things need to be addressed as far as assets and debts and custody and property division and all that. But that will be a temporary order in place until you finalize your divorce. And then that can either be incorporated into your final judgment, or if you go to trial, there may be a new amount of spousal support. So keep in mind, we don't handle contested cases or anything that goes to court. I am familiar with the process and procedure all day long. I did work for the courts 12 years ago prior to starting this up. So very familiar with the behind the scenes. But again, we don't represent clients in court, but procedure and paperwork all day long. Okay, so getting back to this, how long will it last? Talking about spouse support. This is from the court, and then I'll get into some details, so I'm not just reading right off of this, which you guys could obviously do the same thing. The longer you are married, the longer support can last. Support lasts the reasonable amount of time it would take for the spouse to become self-supporting. The longer you are married, the longer it's assumed this will take. The judge starts with some basic assumptions. For marriages less than 10 years, support will last half the length of the marriage. So that's kind of the general rule. And that's why everyone's talking about this 10-year rule. They think that because spouse, once you hit that 10-year mark, spouse support is paid forever. Not necessarily true. It's all about becoming self-supporting in a reasonable period of time. And that's why it said the longer you're married, the longer support might be. But with short-term marriages, which, 10 years is still a long time. So if you're 9.5 years, that would be half the length of the marriage. And you can use that as a general rule, but you can also say you don't want to have any, or you can go longer. We've had clients, we've even had people married 20 years go with half the length of the marriage rule. They like that better than just doing until further court order, which just means an indefinite period of time, not forever, just indefinite. But you can use half the length of the marriage like the folks that have less than 10 years in marriages of short duration as well. So those are the two rules of thumb. If you're going through an amicable divorce, using those as a tool or a reference for how you want to establish support, keeping in mind you get to call the shots. The court will not interfere with your decision making. If you go through an amicable divorce and agree on all terms, again, with long-term marriages, you can terminate that long-term marriage, even though the rule is that the court will maintain jurisdiction indefinitely. You're able to do that instead of having it reserved. Okay, there are points when support will end. Support will end when you agree in writing about the date it will end. The court signs off on the agreement. So again, if you agree to 3 years, 5 years, 10 years, or none, that's when it'll end. The court order that ends the supported spouse remarries, or either spouse dies. So I want to move on because this is getting more into like factors. There's something called 4320 factors. I'm not going to get into. It gets very specific. This is what the court uses to make determinations for spousal support, like how long you were married, your age, your health, your income, just all these things considered that go into not only how long were you married, but how long is it going to take for the spouse who needs support to become self-supporting. Remember, that is the whole goal. Let me see what other questions we had here. So yeah, the reason that we're bringing this up is so you know what the rules are, right? The guidelines, so you can make informed decisions even when going through an amicable divorce, or if you're going to go to court, you kind of know what your options are or what you may be able to get or request in your divorce case. So what is considered a long-term marriage in California? We've already talked about that. That 10-year mark. And there's some references I want to go over written by attorneys that talks about that's not really such a thing, even though it really is. Okay, California long-term marriage and spousal support. We talked about that as far as how long spousal support can be paid. Again, two trains of thought: amicable, cooperative. You guys get to decide. So for the clients we help, what we normally will do, if they don't already come to us with an amount of spousal support they agree to, that happens quite a bit. They'll say we already agree on spousal support and child support, so we don't even have to run support numbers for them because they already agree to a certain amount. But where parties don't know how much they want or what the court might order, and that's kind of how I reference it to our clients today. I can run you a child support and spouse support order to get an idea of what the court might order in your case once we know the incomes of the parties, and then they can use that number to start the conversation as far as how much they want to have for how long, if any at all. So it's really beneficial. And going through, if you guys are amicable, obviously it takes two to be able to do that side of court and don't have to enter the court system at all. Okay, here, this is regarding spousal support. This has been asked a couple different ways. How many years do you have? Okay, how many years do you have to be married to get spousal support? So the length of marriage is only one consideration or one factor in the support. You could be married 30 years and both of you make the same amount of income and there wouldn't be any spousal support. You both are self-supporting, you're both making the same amount of money. There wouldn't be any support even though you requested it and even though it's a long-term marriage. And there's some other underlying factors. So it's not that you've been married, but it will matter. So the question we're answering is how many years do you have to be married to get spousal support? Even if you're married 6 months, again, we don't handle contested cases, but when I worked for the courts 12 years ago, people have been married 6 months and they got 3 months of spousal support because maybe one of the spouses moved in with the spouse that was working, moved into the home, or where one spouse was paying all the rent, and for that period of time, lived off that spouse's income. So there was a need for support, but you would get that short term, you get some small amount of support. A lot of times we're running support numbers where I have a client right now, actually they haven't become a client yet. We're trying to get the parties in agreement. I've spoken with both spouses and they agree on everything except the husband wants spouse support. The first thing I tell them is that let's start the process. Let's get into the financials. Let's run the numbers. And before we start a fight and get attorneys and go to court, let's first run the numbers and see if it's even going to be warranted and what that amount of spouse support might be. Because the closer your incomes are to each other, the less amount of support and less likely support there will be any at all. So that's what we're trying to do. And in some cases where I would say 98% of our clients are 100% amicable start to finish, sometimes we'll have clients that don't want attorneys, don't have the finances for attorneys, but they want to use us, but they're not in agreement. They're cooperative, but they are unable to reach an agreement, kind of like in this case. So what I would do for them, if once we run the numbers, let's say spouse support comes up as, I don't know, I'm going to make up a number, $200. And spouse was going to have to pay, says, well, I don't want to pay it. And the spouse is going to receive it, says, I'm not going to give it up. I really want it. Then what I'll do, just in working as a neutral third party for them, is I will file a trial setting in LA County, which is probably 80% of the cases. The other 20% are scattered all over California. But there's usually with the court some form of a trial setting. Doesn't mean a trial. It just means you get them into court so they can tell the judge what's happening. Hey, we agree on everything, but spousal support in this case, and they can send them to maybe mediate to a mediator within the court or something other than a full-on trial for just a single issue. They can they'll feel better that the court said this is what it's going to be or not at all. Then they come back to us and we wrap up their case. That's probably what we're going to end up doing with these folks I've been talking to for the last couple of days, is just get them started, get into their finances, run the numbers, then let them make the decision. Because maybe spousal support, and we've seen this happen, there's this huge argument of spousal support, and then we run the numbers and there's none at all, or maybe it's $25. And I'll tell them, is it worth spending $10,000 on an attorney if you're going to get $25 in spousal support? Probably not. So we have some questions coming in. I'm just going to take a look here. Alimony and DVRO with no violence and impact on temporary spousal, alimony and DVR. So domestic violence restraining order with no violence. No, only time I'm aware of, and again, just caveat, not giving you legal advice. When I was working for the courts years ago, the only time domestic violence played a part, and with violence, was when the payor was let me get this right. When the victim or the person victimized, the victim of the domestic violence would normally have to pay alimony. They won't make a victim pay the person who, I don't say violated them. That's not the word I'm looking for, but they won't make the person paying support pay their abuser, essentially. Another question we have, Dora, I had a client who made a lot more than the spouse. Judgment clerk wouldn't accept the marital agreement, which both parties agreed to. No spouse support. Clerk said clients can do that. That's interesting. You can't hear me. Well, hopefully you can. I have a couple of people on here, so hopefully my sound is going through. Let me just double check. Mic is on my side, so hopefully that's on your end, not mine. If anyone else is listening, can you let me know, or just say can't hear you, or no volume, or yes, I can hear you, please, just in the comments. And I can answer you later, Dora, as well. But where the clerks are not supposed to be getting involved in the decision making. Now, I want to say you are in Northern California, and we find some kind of funky clerks in certain courts getting involved in things they really shouldn't. And so it can happen, but a clerk shouldn't be able to tell the parties if they agree to no spouse support. And it might be because, I don't know if you've heard of that, and I'm sure you have. There's that waiver language if it's a long-term marriage. Let me just read your comment again. Had a client who had made a lot more than the spouse. Judgment clerk wouldn't accept the marital agreement where both parties agreed to no spouse support. So there's some waiver language. Okay, thank you for let me know you can hear me. Appreciate it. There is waiver language, two sets of waiver language. If it's a short-term marriage, anything under 10 years, there's a paragraph or so of language that I have my clients sign to say that they are knowingly and willingly, without duress, waiving spouse support. We have them initial that. It's very clear cut. So I do that even in short-term marriages. In long-term marriages, it's mandatory. So I haven't seen it mandatory on the short-term marriages because there isn't that rule that spouse support jurisdiction would be maintained for any, for future determination forever. So with the spouse support, kind of lost my track of thought because I'm reading the comments here. But with the long-term marriage, there is like a full page and a half that's mandatory waiver language for the spousal support waiver that they have to sign. So they will reject your judgment every time, every court we filed in. If you don't submit the waiver language or have the parties sign this waiver language and incorporate it into the settlement agreement or part of the judgment, they are going to, okay, you can hear me, great. They're going to reject it. And if you want, let me know, or email me later and I'll send you that language, and you just throw that in there, have the client sign, and that's never been a problem. Same with the child support, getting that not waived, but asking for a non-guideline order. It's very popular with our clients, and there's just a special way of doing that. So we were just talking about how many years do you have to be married to get spouse support. Again, there's no fixed amount of time. Like the court said, the longer you've been married, the potential for more spouse support, but only Income is also an issue as well. If your incomes are the same, there isn't going to be any spouse support. We have some more people jumping on. If you guys have questions, we are answering questions, not just about the spouse support. Wei, did I answer your question about the alimony and restraining order? Let me know if you had another question on that. But go ahead and ask your questions, folks. Anything about forms, judgment rejects, any issues like that, I'd be happy to kind of work through those with you. So how long does spouse support last in California? Again, so this is another question. You can see that these questions are kind of repetitive. They're just coming in a different fashion. So how long does support last? It lasts as long as the court orders it. It lasts as long as you agree to. It lasts until one of the parties dies. So it's really your call. And again, doing this amicably, that's our specialty. The clients going through our service, they choose what they want. We don't get involved. We don't mediate their case. We just give them the information like this so they can make the decisions. We'll talk to them about long-term versus short-term marriages. We'll talk to them about the incomes. We'll run the spouse support numbers for them, and then they will ultimately get to decide. Once in a while, we'll have clients say, "Hey, can you decide for us?" And I'll tell you, that's the kiss of death. You don't ever want to get involved making decisions, because once you do that, the spouse that perhaps, say in this case, was the one that you said, "Yeah, I think you should pay spouse support," they now think you're no longer a neutral third party in their case. Let's see, we got another questions coming in. If the petitioner filed for a legal separation, how can the respondent request divorce? So they just request divorce. Divorce trumps legal separation every time. And then that will stop. It won't stop the legal separation. It will turn it into a divorce. So I don't know. I was just talking about this to someone about that, because I forget what came up. I think they filed for legal separation and then they wanted to change it to a divorce. That's what it was. So we filed for they started out as a legal separation, and I have a whole opinion on that and why it's in most cases not the way to go. But we've had people start with legal separation cases. So let me give you two examples. You file for legal separation, but at some point before the judgment, they change their mind. You don't have to amend the petition to divorce. You just file a judgment for divorce, because you're going to have a settlement agreement. It's going to say that they agree that this is a divorce. And because divorce will always trump legal separation. So if they're amicable, so if the petitioner filed for legal separation, how can the respondent request divorce? Let me know if they're amicable, because if they are, you would just do what I just said. You would just have them just submit a judgment for for divorce, and it should go through. If not, just amend the petition to divorce, refile, reserve. Do it simply. Just use a notice of acknowledgement. You don't have to serve them. But if they're not amicable, file a response for divorce, file and serve that, and that will trump the legal separation. So that's a good question. Again, we're not handling cases where people are going to court or contested, but that's the procedural way that would happen. I have a note here. It says, if amicable, the length of time and support is up to you. So that's what I was just talking about. When it's amicable, no one's going to decide. And this goes with anything that you throw at the court. Anything you guys come up with, I tell my clients, sky is the limit as far as the types of agreements that you want to come up with, you want to reach. People are always concerned what the courts will say. They say, hey, we're not dividing our property equally. What's the judge going to say? They'll say, wait, we don't want alimony. Is the court going to, kind of what these questions are coming in, is the court going to, deny that? We've never had the court interfere with the decisions of our clients. I've always told our clients, just tell me in plain English. Don't worry about making it sound all fancy legally. Just tell me in plain English what you want. I'll doctor it up a bit to make sure it's legally sufficient to what the courts want to see, to just, make sure it will be binding and all that. So just to add on to the question, it says, so my client is, and this is, I'll just read the question in its entirety, I guess. It started with, if the petitioner filed for legal separation, how can the respondent request divorce? It says, so my client is the respondent and he wants to get divorced his wife. He doesn't speak to, so can I request for an order and ask the judge to change it from separation to a divorce? No, so you would just file, in this case, you'd have to file the response and list, respondent request divorce to make that official, get that official response into the court for divorce. And then if they're not talking, I mean, obviously, I don't know if there's going to be a settlement agreement, but the filing of the response will asking for divorce will trump the legal separation. And then, of course, if they're amicable, or maybe petitioner says, well, I'm not going to participate or cooperate now because I don't want the divorce. And usually that's why would someone want legal separation versus divorce? Usually it's for health insurance reasons. That's one of the main reasons people will do legal versus divorce. And even then, I will warn you, check if that is something you're considering, check with your health insurance provider, because a lot of major health insurance companies have been closing that door. At least half the time when I tell folks, they call for legal separation for the intention of remaining on health insurance. I'll have them call and they'll say, yep, sure thing. They would treat legal separation the same as divorce as far as no longer being a dependent, and would have lost their coverage anyways, and then would have just filed for legal separation for no reason. And here's the downside to doing that. If you guys have the questions about, legal separation versus divorce, which comes up a lot, is if you file for legal separation and you finish a case for legal separation, you still have to do all the same decisions. You still have to have support or not. If there's kids, you have to have custody, child support, everything, property division. It's the same process, just a different checkbox on the petition and a different checkbox on the judgment 180. Okay, I'll get into that door as far as what to do next. So you just want to, I got to stop reading these comments. They're throwing me off track. So remind me if someone tell me what I was talking about so I can get back to this. And I'll go back what we're over. Okay, so we're going back to Dora's question. So it's saying that the petitioner defaulted the case. So the petitioner filed for legal separation, the respondent didn't respond, and the petitioner filed a default, which blocks the respondent from filing a response in the case. So default cases, I don't take them like true default cases where there's no agreement. They are the toughest, trickiest cases to get through court. I take them once in a while, but they are a nightmare because everything falls to the California law. But what you can do is file a request for order with the court to set aside the default and enter your response. So it's just it's an easy request. And here's the thing: we never have our clients like purposely default the spouse, well, because they're amicable. So we do if it's a default with written agreement. We're going to do the default when we submit the judgment, but it's default with agreement, not true default. This petitioner probably won't even get the default through, because if there's assets and debts and all that, they're very difficult to get through the court as a true default. Multiple hearings, at least with our courts that we deal with. So yeah, request for order, and it's basically mark the other box, request the court set aside the default and allow respondent to enter response. I've never seen, we've done these in the past where people have come to us where they didn't initiate the divorce. They'd already started the divorce, or maybe the spouse started the divorce and they got a certain way through the process. And now the respondent's calling us and say, hey, this, they're in what's going on in your case, it's been defaulted. And what do I do? I say, well, now you just have to go back to, you're basically backing up. So you're actually going, but the petition was filed, the default was filed. Now you're going to have to file a motion, go back to square one, get the default set aside so you can file the response. And now you're right back where you would have been. So the default is not a absolute, doesn't mean you're absolutely going to get through because you've kicked the party out by filing the default. It's not absolute at all. And every time we've filed a set aside request or motion, it's always been accepted, because this isn't civil. It is civil, but it's not, a lawsuit or something like that. This is, family law. So they want the parties to be involved, especially with their kids and support. And it's easier for the court to make orders when both parties are involved at a trial versus a default hearing or default trial where they don't have the information from the other party. So I'm glad that made sense. So any other questions? It looks like a few other people have popped on. If you have questions about forms, judgments, the process in general, anything outside of legal advice, I think we covered the spouse support pretty good. Been going on here. What are we looking at? About 30 minutes. So that's what we're going to be shooting for. We're going to have some more topics every night, 5 p.m. As long as my wife doesn't get upset at me doing this because I'm missing the dog walks. That's what we normally do at 5 o'clock. And I can hear she just got back. Every day will be a main topic. So, for instance, where's my calendar? Tomorrow, our topic is, oops, our topic tomorrow is, bear with me. I think I just hid my camera. Tomorrow, the topic is, how to prepare a status only judgment. Um, there's a lot of folks who um, incorrectly file status only judgments. Status only means you're filing the um, a judgment and dissolving the marriage only, and you're not addressing all the other assets and debts, kids, custody, all that's left for future determination. So the courts, in my opinion, when I worked for the courts and just handling clients in the past, in the last 10 plus years, the courts kind of frown on the whole status only, because people are usually doing the status only because they can't figure out everything else. But then the courts know once the pressure of the divorce is over, they're not going to handle it. They're never going to come back to court and handle everything else. So they kind of don't want to do that. You can petition the court to do that. We normally are not seeing the courts set aside or allowing for status only dissolution by filing a motion where one party wants it and the other party doesn't. We're going to go into depth on this. I'm actually going to go through the forms tomorrow, step by step. We're going to do a full judgment based on status only, because some of the forms are the same, but some of them are different, and there's some additional bifurcation. That's what, when you do a status only, you're doing a bifurcation, which means all that means is a fancy word for separating the status of the marriage from all the other issues in the divorce. So we're going to go over that. There's additional forms you attach to your judgment. So that we'll be doing that tomorrow at 5, and it'll actually be a walkthrough kind of over my shoulder. I'll have the forms up. I'll be able to share my screen, show you how to complete that and how that goes. We do that for clients who have filed for legal separation in the past. So here's one nuance here. This is usually when we're doing it. Parties went through a legal separation years in the past, and now all the legal separation process is exactly the same as divorce. And so assets, debt division, everything is addressed in the divorce. In the legal separation case, but they're still married. And then 1, 2, 5, 10, 20 years later, they want to do the divorce. And this is the other nuance. Did you know if you do a legal separation case and you finalize it and then you want a divorce, even if it's 6 months later, it's a brand new case. If you finalized it and didn't convert it to a divorce before you closed out and did the judgment, it's a brand new case number with us, brand new fees and court fees. So convert it before it finalizes. Otherwise, you're just filing a brand new case. But totally different forms. We'll go into detail over that tomorrow and the nuances. But if you finalize a legal separation case and now you're just doing the divorce, and you're not going to readdress those issues from that legal separation whenever that was. This case will be filing a new petition for divorce, and you will actually put status only on the judgment because it's just dissolving the status of the marriage. You're not addressing anything in that legal separation case. In fact, if you want to change something in your legal separation case, you wouldn't put new agreements into the divorce if you already have a finalized legal separation case. We had parties that both wanted to file for divorce and make modifications to their prior agreements from their legal separation case. We had to do two different things: file a status only dissolution of their marriage and start a new case for the divorce, but then also file a stipulation to modify their judgment of their legal separation case. So kind of getting into the weeds there, but we'll be going over all of that and the nuances and why you want to file for legal separation and why you don't, and then how the status only dissolution works. Because if you're doing a standard divorce, we've seen clients come to us for help and need to get their divorce finalized, and they have their judgment's being rejected for a whole host of reasons, but a lot of times they're marking status only. I think it's just throwing them off. But you can't do that because it's a whole bifurcation status, and there's additional forms that you have to stipulate to and sign for that. But we'll go over that tomorrow. So unless there's any other questions, I don't see anything coming up. We will close out and join us tomorrow at 5. Again, we're going to do this every weeknight at 5 p.m. Spread the word if you know people that are looking for help or need help. Again, the self-help centers are impacted. Ours in LA County, and again, we work with all the courts in California. But specifically LA County, you can't get help in person anymore. They used to have Zoom help during COVID, but now it's just a call in, And from what I'm hearing from clients who become our clients is that it's really bad, getting wrong information, being hung up on, being on hold for an hour. So we're going to be here, a half hour, an hour, as long as it takes to get people's questions answered, because we'll get you sorted out real quick if you just have a couple things. Usually it's just a simple dotting the I's, crossing the T's, procedural things that we can help you with. And thanks for tuning in, and we will see you guys tomorrow, hopefully, if you have any additional questions.